Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me as always is co-host Sam Kill, Senior Associate with MBK Chapman. Sam, good morning.
Good morning, Mike. Good to be with you.
Good morning. Good to have you, as usual. So, Sam, today we're going to cover a topic that's pretty common, especially in a state like California, where a lot of people come to vacation, and we just have so many people and so many homes, and that is, can my HOA stop me from renting out my property? Mm-hmm. And when I talk about renting out our property, we're going to run the gamut today. We're going to talk about short-term rentals, and within the meaning of, is this kind of property that you would put on Airbnb for, somebody coming in for a week or 2 weeks or 3 days or 5 days, and also, rental properties in the traditional sense, where you're looking for long-term people, long-term leaseholders. Okay, mm-hmm. So we're going to cover that today, and we're going to talk about basically the two statutes in the Davis-Stirling Act, which are almost the entire law on the subject are covered in these two statutes, mm-hmm. and that's Civil Code Section 4740 and 4741. We're going to be referring to those two statutes throughout the entire episode, mm-hmm. okay, pretty consistently. And my goal for this episode, at the end of this episode, I want you to be able to answer the question is, what can my HOA do or not do with respect to me renting out my property? And what can I do if my HOA is violating my rights or violating the law with respect to rentals? So those are the two issues. At the end of this episode, I hope that you can answer with some sort of confidence, okay? Yep. So let's start at the beginning with the legal framework. And I already kind of hinted at the two statutes, Civil Code 4740 and 4741. So Sam, tell me about 4740.
Well, Mike, 4740 is a grandfathering statute that basically states that any rule change or amendment to the CC&Rs in terms of the provisions that restrict rental use, short-term rental restrictions, does not relate back or retroactively apply to those who held title prior to that adoption.
Okay, perfect. So in other words, if you own the property and they do a rental change, a change in either they establish a rule limiting rentals in any way, mm-hmm. doesn't apply to you if you own the property prior to the new rule.
Does not relate
back.
That's it.
Nope. It's very, very simple. And the reason that's an important thing to talk about, and the reason it's in the statute, is because the default kind of position in the Davis-Stirling Act is that grandfathering doesn't apply unless it's in the statute. So
right. Yeah.
If you have an HOA that doesn't have any rules or regulations, or either in the CC&Rs or in the rules that say, for example, no smoking, on your balcony and stuff like that, and they decide to pass that rule, it applies to everybody regardless of when they purchased, unless the statute unless there's a statute in the Davis-Stirling Act that says, by the way, rules related to smoking are not retroactive, which there isn't. Mm. But in this case, the statute says, hey, if you're going to pass rules about rentals, it's not retroactive. So as long as you held title prior to a restrictive rule change, the restriction does not apply to you. Meaning, you could have an HOA, let's say you moved into an HOA that had no rental restrictions at all, just to make an easy case. And you were using that unit that you owned as a short-term rental. You had it listed on VRBO, on Airbnb, and you had people coming in, staying 3 days, 5 days a week. And then they pass a rule saying no more short-term rentals anymore. You can only do rentals of 31 days or longer. Say your HOA did that. Doesn't apply to you. Okay? If the neighbor sells their property and new people move in and they see that you're, doing short-term rentals and they want to do it, too bad. It applies to them. But it doesn't apply to you because you had title before the rule change went in. Now, if you bought into an HOA and there was already a restriction in place, it applies to you. Mm-hmm. Now, if they go and make it more restrictive, the more restrictive doesn't apply. Mm-hmm. But whatever was in place when you moved in does.
Until you sell or transfer.
Until you sell or transfer.
Yeah.
And then the new people that buy from you, they're subject to the complete rule. Okay, so that's 4740, grandfathering mm-hmm. clause. The next provision, and it's really the money one, it's the big one because mm-hmm. it's got all the, this is all the stuff that HOAs can and can't control with respect to restrictions and limitations on your right to rent your property, and that's 4741. And that statute has basically all the rules. So let's start with let's start with, we're going to get through all of them and we'll discuss the specifics. Mm-hmm. I guess now's as good a time as any.
Let's go.
Okay, so 4740 is grandfathering. 4741 says, okay, here are the things HOAs can and can't restrict mm-hmm. when it comes to rentals. And by the way, when we use the term short-term rentals, that means different things to different people. Okay? For purposes of this discussion, because of what 4741 says, I'm going to classify anything of 30 days or less, all the way down to 1 day, as short-term, and anything 31 or more as long-term. It'll be easier if we use the same terminology while we're talking, okay? Now, here's what HOAs cannot do. They can't do this under 4741. You give me the first one.
Flat out prohibit rentals.
Okay. What is flat out prohibit rentals?
They cannot put a restriction, whether it's in the CC&Rs or any rules that they adopt, that simply prohibit any type of rental use of the property.
Right. They can't say every unit here must either be empty or owner occupied.
Correct.
They can't do that. State of California stepped in several years ago and said, no, not going to happen. Okay. So a complete ban, illegal. Perfect. That's exactly right. Now, let's say, and by the way, as we'll talk about shortly, or I'll say it now, 4741 discusses the obligation of HOAs having to amend their governing documents to be consistent with the new laws. When they were passed, they were new, right? A lot of HOAs have not done that. It's okay. To the extent your CC&Rs or rules are contrary to this, for example, they ban all rentals, it's void. Just doesn't matter what they say. Remember the hierarchy we've talked about in other episodes. The law trumps governing documents.
That's right. Yep.
Especially when the law says we trump governing documents. In this case, it does.
It does.
So you're done. Okay? Next thing. So no complete ban. Great. They cannot ban rentals for anybody's properly constructed ADU or JADU, junior ADU. Now, of course, we've done prior podcast episodes on ADUs and JADUs, and that's accessory dwelling unit or junior accessory dwelling unit. And there are multiple articles on the subject on my website, mbkchapman.com, under the libraries tab, and just type in ADU and you'll find a ton of articles and fact sheets. And we're not going to get into what those are today, only so far as to say that, as you'll see a little later in this episode, ADUs and JADUs have a very special role when it comes to rentals, and we'll get to that. That's a little teaser, but they're treated differently than the main home. That's really the message. But so HOAs can't do a complete ban on rentals. They can't say no rentals at all, and they can't say, okay, well, you can rent your home, but you can't rent out ADUs or JADUs. They can't do that. Okay. The next thing is the most confusing part of what's in this law, and that is the cap. And the reason it's confusing, this is a guess on my part, but I think the reason it's confusing is because people read it as if it's like a double negative, and it's very sloppily written. The statute itself is not, this part is not well written at all. And it can be viewed from two perspectives. What can the HOA ban? What percent can they ban, and what percent must they allow? And if you have two people talking using the same language, but each is looking from a different perspective, they're going to come to opposite conclusions. That's why people get confused. I'm going to try to lay this out very simply. And here it is. An HOA, so HOAs can't ban outright rentals, but what they can do is say, okay, we're going to put a cap on the number of homes by a percentage, the number of homes that can be rented. So the law allows them to cap the number of rentals. And the law goes further and says, and we're going to give you a maximum cap. And that is, there's 25% figure, a maximum cap of 25%. 25%, what does that mean? Does that mean that they can ban people from renting anything more than 25% of the homes in the unit, or must they allow 75%? I'm going to make it simple, okay? Let's assume that your HOA has 100 homes. Your HOA can, if they're using the maximum limit, cap limit that the law sets forth, they can say only 1 out of 4 homes can be rentals. The other 75 must not be rentals. They have to be empty or owner occupied. They can do that. But they can't say, well, no, we don't like that. We want to ban 80 homes from being rented. They can't do that because that would be over 25% cap. That is a maximum cap. So if they want to stop 1 out of 4 homes from being, or if they want to allow 1 out of 4 homes to be a rental, they can do that. But they cannot increase that number. They can't make it less than 1 out of 4. Okay? And the flip side is they can ban the majority. They can ban 3 out of 4 homes from being rentals. That's all you got to understand. Just think of an HOA with 100 homes and say the maximum they can do is ban 75 from being rentals, but they have to allow at least 25. That's all you got to remember. Now, here's something very special about the cap that I alluded to a few seconds ago. I'm going to let Sam fill us in on a cool little secret. And what is that secret relates to JADUs and ADUs and the cap?
Yeah, well, basically, ADUs and JADUs, Mike, are they're not counted against this cap. So basically, meaning that if even though the main dwelling, where the APN, I guess, tracks is essentially prohibited from renting, the ADU or JADU is exempt. So you can go ahead and, although prohibited on your main dwelling, you can rent out your ADU or JADU.
And prohibited. So let's say in this example, let's say that your HOA has a cap in place, because the cap doesn't apply unless it's in the governing document. So let's say they have the 25% maximum cap, and your HOA is already at that limit, and you want to rent out your house. Well, you can't, because they're at the cap, and that is a legal cap as long as they're within that 25%. Yeah. That's legal. So you can't rent out your main home, but you can rent out your ADU or JADU, depending what you have. And by the way, those are called granny flats, casitas, guest houses. They're defined in a lot of ways. But again, you find that in the other episodes we've done and in the articles on the website. But you could literally be prevented from renting out your home, but you can go ahead and rent out your ADU and JADU regardless of any cap, because caps don't apply when you're counting up the numbers. The cap doesn't apply to JADUs and ADUs. Right. That is a big deal.
It is.
Because if you are one of those properties that has an ADU on your property, you basically have a mechanism of, as long as it's a legal ADU, and I won't get into what defines an ADU, but you have a mechanism of never being able to be prevented from renting at all, unless your HOA has a ban on short-term rentals. And I want to touch base on one other aspect of 4741 that's very confusing. And it's so confusing that most HOAs actually get this wrong. And how do I know that? By experience, but also I have with me Sam, who used to represent HOAs. And he was telling me how many of the governing documents, and of course I can confirm this because we see them too, I'll get to the statute first, and then I'll tell you why there's a problem. Technically, under the statute, I told you early on today that we were going to define short-term rentals as anything 30 days or less, and non-short-term rentals is anything 31 or more. But a lot of the HOAs have this term that they view the statute, and this is wrong, folks, but they view it as less than 30 days. So they can ban less than 30-day rentals. That's wrong. They can ban 30 days or less. The statute puts the 30 as part of the short-term rental. So an HOA is perfectly allowed to say, we are not allowing any, forget the cap, we're not allowing any rentals of 30 days or less. End of story. But when it comes to rentals of 31 or more, they must allow at least 25% to be rented out. And that's where the cap comes in. So just remember that. Short terms can be completely banned, but anything 31 or more cannot be, but it is subject to a cap if your HOA has voted to have such a cap in place or passed a rule imposing such a cap. And then that cap can't be maxed out at more than 25%. Now, part of the statute, 4741, did require HOAs to amend their governing documents to conform with the law when it was new, when it was passed just a few years ago. I think this happened in 21 and 22. And many HOAs haven't done that. They just haven't gotten around to it. No worries. Even if your governing documents, your CC&Rs, your rules say no short-term rentals and no long-term rentals, or it says we have a 50% cap in place, it is void. Disregard it. It is not of any legal effect. You don't have to worry about it. Okay? No matter what your HOA says, it doesn't matter what your governing documents say. The law says X, and that's what the law is. Okay? Now, here's a good one. A lot of HOAs, and tell me if you agree with this, Sam, a lot of HOAs say, okay, we've got we're going to vote a cap in place, so we're going to do that 25% thing. And we're banning all short-term rentals, but if you are within the cap and you're one of the long-term rentals, here's what we require. And this is often not in the governing documents, but they suddenly they send a letter saying, okay, we want a copy of your lease. We want the name of your tenant. We want to know what your security deposit was. And we want you to confirm in writing that you have given your tenant a copy of the rules and the CC&Rs. Okay. And by the way, that last one is actually a pretty rational thing to do, because even though the HOA can't discipline your tenant other than canceling their fob for the pool and all that stuff, they could do that. But who gets punished is you, the owner. We have an episode that covers that as well. You're responsible for your tenants, and you're the one that they're in privity with, so you're the one that's going to get it. But your HOA, unless the governing documents specifically say, and again, it could be the rules or the CC&Rs, they are not entitled to a copy of the lease, the name of the tenant, the amount in rent, any of that stuff. Now, if the government documents do say, look, if you're within one of the 25% we're allowing to rent out, you must give us a copy of the lease, then you have to.
Right.
You have to. Okay?
And you're right. That is very common. And oftentimes the main transgressors are the managing agents. They
That's
just
right.
kind of create additional hurdles and additional requirements.
In other words, they can't create hurdles that are not set forth very explicitly in the governing documents. That's the bottom line there. But if they do go to the trouble of saying, then they have a right to demand proof that you've given a copy of the rules. Maybe have a thing signed by the tenant saying, I've received the CC&Rs and I've received the rules. Okay? They have a right to know the name of the tenants and the people in the household. If there's parking regulations, of course, that they're going to have to know license plates, stuff like that.
Yeah.
And they have a right to see and store a copy of your lease. Okay? But if the governing documents don't say any of those things, they don't have a right, even if they decide this is what we want. Too bad. I don't care what you want. Tell me what I'm obligated to do. Right. Keep that in mind. Now, if an HOA violates 4741, you have remedies, don't you? Okay? You have statutory penalties. They're not that much, but it's something. Do you remember what that is off the top of your head?
Not the amount, unfortunately.
$1,000.
Is it 1,000?
Up to.
I wasn't sure if it was 500 or 1,000.
It's up to the judge.
1,000, yeah.
Statutory damages of up to $1,000.
Okay.
Okay, for a willful violation. Well, not even willful, just a violation.
Yeah.
Okay. Now, that's nothing. It's $1,000 in the scheme of things is not going to be something.
It rarely comes up. Yeah.
It's irrelevant.
Right.
But what is something is your actual damages. And that's where the real money can come into play. So if your HOA, and the reason we're going so minutely over this law is because when you're right, the penalties for the HOA can be, depending on your circumstances, can be huge. Here's why. $1,000, up to $1,000 penalty, fine. Okay? Attorney's fees, enforcement of governing documents, blah, blah, blah. You're entitled to that upon prevailing. Okay, great. Those are good too. But the good one is your actual damages. And what are your actual damages? Well, let's give an example. Let's say I want to rent my home out. My fair market value for my rental is $7,500 a month. Okay? We have a client that has a rental home in Hermosa Beach that's a block away from the water, and their fair market rent there is $17,000 a month. But let's say yours is $7,500, okay, a month, and you're not at the cap. Your HOA either doesn't have a cap or has a cap, but the rentals haven't met that cap, okay? And your HOA says, no, we're not going to allow it. Okay? They can't do that. They can't. If you're under the cap or there is no cap, they can't prevent you from renting. They have no power to do that. Okay? But they do. They tell you if you rent your property, we're going to start fining you. And let's say they bring you to a hearing, they start fining you, whatever. So you start going into it with your HOA. So let's say you put it up for rental, or you sought to do it in January just to make things easy. Okay? And you try all the things. You call us. We get involved. We go to ADR. Now several months have passed. Okay? You go to ADR. It fails. And you decide, you know what? Screw that. I'm going to sue. I have a right to rent my property. I want to sue. You sue and you prevail. You get your attorney's fees. You get your $1,000 in statutory penalties. But it took 2 years to get to trial, go through trial. Now we have 24 months at $7,500 a month.
180.
Yeah.
180K.
Yeah, $180,000.
Yeah.
$180,000. in actual damages, plus all your attorney's fees and costs, plus your $1,000 statutory penalty. Don't forget that. Okay? In other words, every month that you are prevented from renting, and here, mitigation wouldn't really be a thing. If you're getting constantly fined or brought to hearings, or they're suspending, rights depending on the kind of community you're in, you're really not in a position to mitigate by renting it out anyway. So every month that goes by where it remains empty, and you had you were ready to go, market's hot, let's say, and it wasn't hard to rent at the time. Those are damages, folks, and it adds up. It's very simple. Yeah. It's your fair market rent times the number of months that you've been prevented from renting. There it is. Those are your damages. So there's a real consequence for an HOA violating 4740 and 4741. We had this come up in a case most recently, about 6 months ago. It was the end of the case, where we had clients who under 4740 were grandfathered. Their HOA had, because of massive, and they were valid, there were issues with Airbnb type guests and vandalism and noise and all that. And so HOA was, I can understand why they were reacting the way they did, but they passed this unilateral rule banning all short-term rentals. So anything under 31 days, basically. You said anything under 31 days you can't do. Well, our clients had lived there for, owned that property for 20 years. And they came to me and said, they're banning us, one of my rights. And I explained to them, no, you fall under the grandfathering statute, 4740. We wrote letters to the HOA. HOA disregarded that. They said, no, we don't agree. It's mind-bogglingly wrong. Mind-bogglingly wrong.
Yeah.
But they forced our hand. We had to file a lawsuit. And the case settled. The insurance company, when they got involved, the insurance counsel took a look at it and said, what are you doing? So long story short, our clients got every dime of their attorney's fees. We refused to discount it even one dime, every dime, because they could have gotten out of this for under $5,000, and they chose not to. So every dime of the fees that were paid, and a letter acknowledging our client's right, as long as they own the property, to Airbnb and VRBO their property to their heart's content. Not in those words, but that was the message. Okay, so it's a big deal. Okay,
yes, yeah.
And now let's talk about the flip side. What can HOAs do under 4741? Well, they can pass an absolute restriction of rentals from 30 days or less. So they can say you may not rent your place for 30 days, or 29 days, or 28, or 27, all the way down to 1. Okay, they can unilateral ban. But the second it goes beyond that, they're running afoul of 4741, so they can't do that. But they can ban up to 30 days. Okay? They can pass a rental. They can prevent you from renting 3 out of your 4 homes. Okay? But they can't increase that. Okay? 3 out of 4 is their cap. Okay? They can force you to you and your tenant to abide by all governing documents, meaning even if you didn't give your tenant a copy of the governing documents or the rules, a violation by your tenant who isn't going to know those, isn't going to know the pool hours unless they're posted. If it's a realtor, isn't going to know the parking rules or any of the other things. If you didn't give it to them, it doesn't matter. Ignorance is no excuse. You, the homeowner, are going to be the one that's going to get fined.
Absolutely.
Okay? Your tenant can't be blamed for it, but you can. Now, if it comes to a point where your tenant can't be called to a hearing, you can. But if, let's say you don't show and they decide to suspend certain privileges, like your fobs will no longer work for the pool, then your tenants suffer. And now you're in breach with your tenants because that's one of the amenities that they signed their lease for. So you've got to make sure that your tenants know what the rules are. So it behooves you, even though the HOA can't require proof of it unless it's in their governing documents, it behooves you to make sure that you give your tenant a copy of the CC&Rs and the rules and say, read these, because if you breach them, you're in breach of our lease.
Yeah.
Okay, you want that. Okay? And now let's get to the last chapter of this episode, and that is, what do you do if your HOA is violating your rights and or violating the statute regarding rentals? Okay? Sam, what's the first one?
Well, Mike, with these types of matters, a good starting point is always to send your HOA, your board, through the property manager, a simple, courteous letter requesting...
Or an email.
Or an email, yeah. the basis for their decision in terms of restricting you or prohibiting you from your rental, specifically asking them, can you cite to the operative provision in the CC&Rs and or the rules that states that you're relying upon or provides support for your decision making on this. And then I would go one step further in that same correspondence and actually ask for their opinion on whether their position comports with what's contemplated under the statutes, specifically 4740 and 4741.
I'd actually go a little further than that. I agree with you. The first thing to do in writing is say, I want you to explain to me very clearly what provisions of our governing documents, our rules and or CC&Rs you're relying on to prevent me from renting out my unit because I believe I have a legal right to do it. So tell me what you're relying on.
Right.
And then the next part, I agree with you, and I would phrase it this way. Something along the lines of, and give me an opinion, whether it's yours or you go and seek it from the HOA's counsel.
Right.
Give me an opinion as to whether or not the provisions that you're relying on, assuming that they abide by my first request, I want you to tell me whether you think the provisions you're relying on are actually in compliance with 4740 and 4741. That's the way I would phrase it. And here's why. Remember, we told you earlier, a lot of HOAs have gotten around to amending their governing documents, even though the statute said they're supposed to do that, to comport with this law when it was passed. If your HOA is one of those, and they are relying on, look, we can point to the CC&Rs and the rules that you're violating, and this is why we're saying no.
Yeah.
Your argument is, aha, that's great. I appreciate you telling me that. But that violates 4741. Let's say that cap was greater than 25% because it used to be allowed, right? Or we don't allow rentals in this community at all. Or ADUs under our cap, you would be over it because if you rent your ADU out, you'll violate the cap. Well, wait a minute. 4741 specifically says ADUs aren't to be included in the cap. So even though they might be able to come up with a provision of the governing documents that and it says what they say it says, might not be in compliance with the code.
Correct.
So I would ask them to do that. Now, they could tell you to go to hell. They don't have to go to the lawyer and spend money and ask. That's within their purview. But boy, do they look bad if you end up being right and they're wrong.
Yeah. That's
not going to look good later. It's going to come back and bite them big and hard. Okay? Because we told you already what the consequences were to this HOA. And I would let them know that. Say, I have tenants ready to go to pay me $10,000 a month, just for the math, okay? And if you take this position and you refuse to go ask our lawyer whether or not you're right or I'm right, then every month that I can't rent at $10,000 a month, I'm going to make sure you pay me. So if this takes me 3 months, 6 months, 9 months, a year, you're going to be owing me $10, $20, $30, $60, or $120,000. If I were you, I would take this to our lawyer, spend a teeny bit of money, and ask for an opinion because you are wrong and I know I'm right under the law. That's the message you put in the email. Now, if you don't want to do that email, come to us. We'll write it for you. And believe me, it'll say the same sort of thing. But we will put them on notice what their damages are going to be so they can't say, we didn't realize. And we're going to let them know why they're wrong. Yes, your governing documents say that, but here's what 4741 says. You never amended your governing documents to comport with the law, which, by the way, is a violation, and you've compounded it by not asking the lawyer for his opinion, even though I've told you you're wrong. I've given you plausible argument as to why you're wrong, and you are refusing to check your ignorance. You know what else that triggers, Sam? Remember, you're allowed to reasonably rely on the expertise of vendors and experts.
And that judgment rule.
That's right.
Yeah.
And that falls under the business judgment rule. But if you purposely keep yourself ignorant and you don't go seek it when you reasonably should, you don't get the protection of the business judgment rule anymore.
That's correct.
You might even get some personal liability because that is, in my opinion, grossly negligent. So you can put them, this is part of what I cover in my book when I talk about stacking. Okay? When I talk about leverage and stacking rights, this is part of that. It's covered in chapter 12. So if you are one of those people that's protected under grandfathering provision and they have a provision in the governing documents, they cite it to you, and it does comport with 4740 and 4741, okay? It comports with it. Well, 4741 really, okay? But they are missing the 4740 grandfathering aspect or subsection H of the 4741, the grandfathering aspect. And yes, those rentals are in place now, and yes, they apply to a lot of people that live there, but they don't apply to you because you had title of the property before that went into effect. You can point that out. So you look for that, okay?
Yeah.
And then, so after checking the grandfathering, okay, when did this pass and when did I buy? That's it, easy peasy. Or does this conform to the current statute, regardless of what our governing documents actually do say? And then look for conflicts with 4741, right? Is there a complete ban on rentals? Are they saying no to everybody? Because if they have a de facto, if the rules allow for the cap, but they are turning everybody down, then they're really ignoring the cap and they're doing a de facto nobody can rent.
That's a good point. Yeah.
A lot of HOAs will try that. Oh, well, we allow up to 1 in 4 rentals. We're good. Yeah. But meanwhile, if you look at the amount of rentals, it's not. There aren't any. You can't do that. Okay, it de facto is a violation.
It is.
Okay, and then look to yourself, Sam. If you think it's worth it, and sometimes it will be, you might try IDR on your own.
Right.
Okay, internal dispute resolution, which is very different than the next thing. But that is, if a homeowner asks for it, HOA is obligated, right?
They are, absolutely.
Sit down with 2 or more, or 1 or 2 or 3 members of the board and talk it out.
Under 5910, by the way, the civil code.
Give your position. Under 5910, give your position. They give you theirs. I would document that meeting afterwards in writing saying, well, thanks for meeting with me. I appreciate it. Unfortunately, we didn't come to an agreement, but here's what I said. Here's what you said. Here's why you're wrong. My next step is to move forward with legal action. And that would be ADR, alternative dispute resolution. And under the confines of the Davis-Stirling Act, when I say ADR, I'm talking about Civil Code 5930 ADR, and I'm talking about basically mediation, okay? Yeah. And that is, if you will recall from some of our previous podcasts, 5930 basically says, okay, these kinds of cases, ADR is required. And the requirements are basically as follows, okay? If you're suing only for declaratory writ or injunctive relief, or you're suing for 1 or more of those 3 things in conjunction with money damages of less than $12,500, which is a small claims limit. That's when it's required by law, and if you don't do it, there are some serious potential financial consequences. Right. But since, as we've talked in this lawsuit, if you're being prevented from renting, your damages are almost certainly going to be more than $12,500, no matter what. Technically speaking, it's very small chance that 5930 will actually require ADR in your case. But remember, and this is something I've written about in articles as well, and what we've talked about in our episodes dealing with 5930 and ADR. You can look for those on our YouTube channel or wherever you listen to your podcasts. Just because it might not be technically required a lot of the time, it's almost always recommended. Unlike IDR, which is often a waste of time, ADR is almost never a waste of time, because we can routinely, first of all, we're going to get you in front. We're going to get you and your HOA in front of a neutral retired judge, because we insist on that, okay? And to basically read on the Riot Act, because we don't do this unless we're right, okay? And more importantly, you have this third-party neutral educating not just the lawyer, not just you, but educating their lawyer and the board about what they're doing wrong, okay? And more than 50% of the cases settle at that stage. So it's worth spending a fraction of the money you're going to spend in litigation. It's worth spending it with an attempted ADR, especially because if you have to proceed with litigation afterwards and then you prevail, your attorney's fees will trace all the way back to the ADR anyway. You'll get all that back. So it's almost always a good idea, whereas IDR is often a waste of time. ADR is almost never a waste of time. So I recommend that. Now, before I wrap this up, I do want to cover an aside that I kind of struggled with deciding whether I was going to say this. And it's one of these rules in the Davis-Stirling Act, it's one of these requirements that I can't think of anybody that's really ever abided by it, including myself. I've never abided by it in my life. So technically speaking, there's a rule in the CC&Rs that requires every homeowner to, on an annual basis, to confirm with their HOA whether or not they live in their home or whether they have a renter, stuff like that. Okay? But there's no penalty for noncompliance. And if your HOA were ever, and I've never, ever heard of one doing this, but if an HOA were to ever send something out demanding compliance, because there's no affirmative duty in this. The statute doesn't say you must take the initiative and do that. So you could always say, well, I was just waiting for you to ask me. So if the HOA does ever do that, again, I've never heard of one doing it, you could just answer the question. Because technically you have to provide them. I live there, nobody's living there, or I have a tenant there. Mm-hmm. So that's technically in the Davis-Stirling Act. I've never, ever, ever provided that report. And I've never had an HOA ask me to do it. And I've never had a client report that an HOA asked them. And I've never heard of a client actually complying. So it's one of those provisions. I'm not even sure if anybody remembers it exists. Is that your experience too?
Yeah, I mean, I don't live in an HOA, fortunately.
Wow, one of the few.
Yeah, one of the few. I mean, I have an option to opt into like a lake HOA, but once you do, it's in perpetuity. So we've stayed out of it. But you're right. I mean, we don't see that exercised. Neither have any of our clients, PCs.
Yeah, it's one of those weird,
interesting,
weird part of the Davis-Stirling Act.
Yeah,
and quite frankly, I can't remember the code section, to be honest. But
my mind went to lending and mortgagees, kind of looking for owner-occupied confirmations and things of that nature. But yeah, it's interesting.
But it's the HOA. It's not a duty to report.
That's right.
Otherwise, it'd be in your loan docs.
Correct.
It'd be in your deed of trust. It'd be in some agreement with the lender. This is Davis-Stirling Act, which is between HOA, the homeowners, and the HOAs themselves. So,
well, the thought process was if you state something and disclose something that runs afoul of, let's say, your loan documents.
And they ever got a hold of it, sure. And the moon was made of green cheese. Bottom line, folks, your HOA can place some limitations on rentals that aren't short-term, which is 30 days or less. But those rentals those limitations are set forth in 4741, and they can't go beyond that. You have a right to rent out your ADU in any regard because no cap applies and they can't prevent you from renting your ADUs out. So that's almost
right.
Carte blanche.
Yeah.
Okay. If your HOA is running afoul of the law and your rights and any efforts you've taken on your own behalf are not working, then that's when you come to us at MBK Chapman. And as usual, we'll set your HOA straight. Trust me on that. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel HOA Hell. If you have any questions or comments, we'd love to hear from you. As always, until next time,